Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Illinois, we're going to talk again. And yeah, as usual, every time we talk, it's never good news. And I apologize. Hey, don't shoot the messenger, okay? Listen, it's bad enough that you live in perhaps the most unconstitutional regime anywhere inside the United States, but think about if all of a sudden law enforcement became complicit in the civilian disarmament efforts. And what I mean by complicit is actually start fabricating stories to disarm otherwise lawful and responsible gun-owning Illinois residents. Don't think it can happen? Well, guess what? I found a case, and that's exactly what happened. But here's the cool thing, at least for now. Yeah, the officers all claimed that they were going to get immunity from their actions, and the court said, no, I don't think so. And that's the cool part that we're going to talk about and geek out on today. So today, let's tell you a pretty crappy story, and let's talk about how Illinois will use dirty cops to disarm their own. Okay, Illinois and America, because I think everyone in America really needs to be aware of this case. The case we're talking about is called Kuhlman v. Hines et al. Hines et al. Will involve multiple police officers here. Now, Robert Kuhlman, who is a resident of Normal, Illinois, and I don't know if there's anything normal about this at all, received multiple phone calls in the evening hours in July of 2023 from his mother, okay? His mom had said that someone had stopped by the house, asked to use the phone. She had let him in to do so. She had then escorted him out of the house, but they would not leave the property. She had made multiple requests for the individual to leave the property. He would not do so. She had called 911 and asked police to come. They were supposedly en route, but no one had gotten there. Mr. Kuhlman actually received multiple phone calls. Each time, mom was getting more and more anxious and scared about the situation. Mr. Kuhlman got into his car, drove to his mother's home, which was also in Normal, Illinois, and found a rather deranged individual sitting on the back porch, and that individual refused to leave the property when Mr. Kuhlman decided to order him off there. Then Mr. Kuhlman, who was a FOID card holder, withdrew his firearm and held the individual at gunpoint until law enforcement could arrive. When law enforcement arrived, two police officers in particular arrived, they found that this individual didn't necessarily pose a threat, but was really not playing with a full deck. Ultimately ended up taking him to a mental health facility that evening. They did confiscate Mr. Kuhlman's firearm, but then they returned it to him that night. End of story, right? Mom got spooked by some guy who's got some pretty significant psychiatric issues. Son came in, made sure mom was safe until law enforcement arrived, and then everyone lived happily ever after, right? Wrong. Because a few weeks later, Mr. Kuhlman got notice from the Illinois State Police Department that now someone was trying to revoke his FOID card. And who would that be? Oh, that would be the officers who responded to his mom's home that evening. That's right, because the officers here are accused in the pleadings of the following. Later, defendant Hines wrote and signed, and defendant Serena Cunningham, his supervisor, countersigned a report submitted to the Illinois State Police, ISP, pursuant to a section of Illinois Firearm Owners Identification Card Act, FOID Act, providing that a law enforcement officer who determines any person to pose a clear and present danger to himself, herself, or others shall within 24 hours of making the determination notify the ISP that that person poses a clear and present danger. That's right. The officers now were claiming that Mr. Kuhlman was a danger to himself and others. But oh, guess what? It gets way worse, because check this out. In the report, which plaintiff states he has read, defendant Hines wrote that he and other officers were at the address in question to conduct a well-being check and did not mention that plaintiff's mother had initiated the encounter by calling emergency services to express concern about a trespasser. Defendant Hines also noted that he did not perceive the stranger to be a threat, and he stated incorrectly that plaintiff had been charged with aggravated assault. Yeah, that's right. They flat out lied and fabricated a story to revoke this guy's FOID card. Now, is he suing to determine that this whole thing is unconstitutional? Nope. He's not doing anything of that. No, this is personal to Mr. Kuhlman. He is suing for compensatory and punitive damages. But this is one of the things that I found out in geeking out for this story is that this FOID Act, which I really thought was the most unconstitutional pile of crap ever passed in the history of the United States, turns out that in that, if officers do things that are negligent or even reckless, they have absolute immunity under the FOID Act as well. And as a matter of fact, the state of Illinois not only tried to say that state law prohibited any kind of claim against the officers under state law, it also precluded Mr. Kuhlman, the plaintiff, from filing a 42 United States Code Section 1983 claim, which is a deprivation of constitutional rights, which is then pled under federal law. Okay, so they are claiming multiple layers of essentially immunity, plus the immunity that officers get of qualified immunities, right? So they got 3 layers of immunity here. And so for that reason, the state of Illinois obviously argues that, hey, case should just be dismissed. But guess what? The court has said, no, we're not dismissing this case because, in fact, we do believe that there is liability here potentially. The bulk of the motion to dismiss is concerned with immunity defenses, which will be discussed in the sections below. Defendants raise only one argument as to why the plaintiff fails to state a claim on count 1. Defendant officers did not deprive the plaintiff of his rights to keep and bear arms. The Illinois State Police did. Yeah, that's right. The officers here are saying, hey, listen, yeah, sure, we may have lied and fabricated a story and all that, but, we're not the ones that revoked his FOID card. No, that's the Illinois State Police, so he needs to take that up with them. The court here correctly pointed out, it cannot be said that the defendant officers' alleged fabrication of criminal charges against plaintiff and omission of key facts about the encounter in question were not the proximate cause of the administrative decision stripping plaintiff of his rights. Now, as I mentioned, when I was geeking out about this FOID Act, I did not realize that there were so many unconstitutional provisions, including one that basically just makes everybody who does anything under the FOID Act immune from civil or criminal liability. The Act itself states, Illinois' FOID Act establishes that the physician, clinical psychiatrist, qualified examiner, law enforcement officer, or school administrator making the clear and present danger determination or his or her employer shall not be held criminally, civilly, or professionally liable for making or not making the notifications required under this subsection except for willful or wanton misconduct. Okay. Now, as to the 1983 claim, the state of Illinois is arguing that, hey, the FOID Act says you can't sue us at all, so you can't even sue us under 1983. There's a big problem with that. It's called the Supremacy Clause, right? And we've talked about the Supremacy Clause most recently here about this state legislature that got a little cavalier about things. But essentially, federal law will always reign supreme over state law, which also means that state law cannot make an individual immune from federal liability, as the court points out. Conduct by persons acting under the color of state law, which is wrongful under 42 U.S.C. Section 1983, cannot be immunized by state law. A construction of the federal statute which permitted a state immunity defense to have controlling effect would transmute a basic guarantee into an illusory promise, and the Supremacy Clause of the Constitution ensures that the proper construction may be enforced. Okay, and then under the state claim, as we know, nobody can be sued under the FOID Act unless they act in willful and wanton misconduct, okay? And guess what? What the court here has said is, hey, listen, you know what? These officers are basically making up a story. They're cooking up a story, which of course is submitted under penalty of perjury to the Illinois State Police Department. You get this guy's rights revoked. Now you're saying, hey, it's out of our hands altogether. That sounds pretty willful and wanton in nature. Then, of course, officers and government agents in general have qualified immunity too. They just simply have it because of what they do for a living. But there are exceptions to qualified immunity, including if you absolutely positively know you're depriving a person of their actual constitutional rights, which the allegations here kind of state. So the court points out, furthermore, defendant officers' framing of their qualified immunity defense fails to address the argument plaintiff advances in his reply, that they violated his clearly established right not to be deprived of his constitutional rights on the basis of a false report made by the police. And so in ultimately denying the police officers' motions to dismiss, the court has ruled these allegations, assumed to be true at this stage, are sufficient to state a claim under Illinois law based on the theory that defendant officers behaved in a willful or wanton manner such that they are not immune to suit under the FOID Act. Okay, it's early. This is just on a motion to dismiss by the defendant police officers here. That has been denied, but this is definitely a good sign. The case, once again, is Kuhlman v. Hines. We'll link it up down below so that you guys can all geek out on it for yourself. And this will certainly not be the last video we do on this. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, and in Illinois, that appears to be next to nothing right now, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information, it's down there in the description box. Maybe you got an idea for a video we should be doing. If you do, go ahead and click on that link right there. Let us know. It's probably better than any idea we're going to come up with. Maybe you just want to be part of our monthly newsletter. The ability to subscribe to all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.